With this, we'll move on with panel number 4. The topic for panel number 4 is the pillars of prosperity, unveiling the judiciary's role in the economic growth and development. This panel will be moderated by Honorable Mr. Justice Retired Shahid Jameel Khan of the Lahore High Court, who will be discussing his thoughts on the rule of law and economic stability, discussing how the judiciary's enforcement of the rule of law contributes to economic stability. Our first speaker in this panel is Honorable Justice Asim Hafiz of the Honorable Lahore High Court, who will be discussing his thoughts on the investor confidence and judicial decisions, exploring the impact of judicial decisions on domestic and foreign investor confidence. Our next speaker in this panel is Honorable Mr. Justice Mia Gul Hassan Aurangzeb of the Honorable Islamabad High Court, who will be sharing his thoughts on the judicial reforms and economic development, understanding the correlation between judicial reforms and economic development. Our next speaker is Honorable Mr. Justice Arshad Ali of the Honorable Peshawar High Court, who will be discussing on overcoming frivolous litigation, use of admin courts and court cost consequences and sanctions. Our second last speaker on this panel is Honorable Mr. Justice Adnan Iqbal Chaudhary of the Honorable Sindh High Court, who will be discussing his thoughts on dispute resolution and economic progress, analyzing the role of judiciary in ADR and its implication for economic progress. Our last speaker on this panel is Honorable Mr. Justice Ali Beg, who is the Honorable Chief Justice of Gilgit-Baltistan High Court, who will be discussing the recommendations for Pakistan to enhance the economic development from a judicial perspective.
Bismillah ar-Rahman ar-Rahim. Assalamu alaikum to all the participants, and thank you very much, the organizer of PIWD 2024, for the opportunity of being a moderator of this distinguished panel of judges representing their respective high courts. And this is the first time, as has already been said by Mia Shiraz, that all high courts of the country are here represented on this very important topic. And I'll start with the introduction, and not very lengthy introduction, of the judges sitting in the panel, except saying that मैं तेरा नाम ना लूँ फिर भी लोग पहचाने कि आप अपना तारुफ हवा बहार की है. Those who are sitting here know them all already, and I formally welcome Mr. Justice Asim Hafiz from Lahore High Court, Mr. Justice Mia Gul Hassan Aurangzeb from Islamabad High Court, Mr. Justice Arshad Ali from Peshawar High Court, Mr. Justice Adnan Iqbal Chaudhary from Sindh High Court, and Chief Justice Gilgit-Baltistan, Justice Ali Beg Sahab. The topic, as is reflecting on the screen, is Pillars of Prosperity, Unveiling the Judiciary's role in economic growth and development. And before starting, and the topic which has been given to me is the role of law and economic stability. Before starting formally, I just want to unveil another thing, that is the conspiracy by Mia Shiraz Saab, who told me, I said that I just left the judiciary and you have made me moderator before judges from 5 high courts. And he said that only you can ask them questions, none other from the lawyers. So I'll be, being old colleague, will be moderating and asking questions on the topics. And the first topic, after introducing my topic and speaking briefly and crisply on it, I will hand over mic to the respective judges. Rule of law and economic stability. The first of all, I want to explain, as I said in my last conference, in the PWD ID conference at Lahore, that rule of law is not properly understood by the people who use this word but don't understand that it is not the judiciary alone who has to implement the rule of law. And in 2021, Pakistan ranked at 130 out of 139 countries on rule of law index, and importantly, it was not the court system. I gave the data last year that courts are deciding the cases more than those are being filed. But number of cases being filed is so huge that the pending cases number is still in millions. So the effective enforcement of rule of law, as I said, is a collaborative effort by judiciary, law enforcement agencies, regulatory authorities, civil society, bar association, journalists, NGOs, and the citizens by obeying law, reporting crimes, and participating in legal process. The rule of law plays a critical role for economic stability and functioning of well-governed, stable country, and the tools are reduction in corruption. By reduction in corruption, if officials are held accountable for delay in administrative decisions on the matters of public and relating to investors and their business due to corruption, the certainty by reduction in the corruption, certainty will come in the system. People shall start believing in the system, and as has already been discussed many times, that foreign investment can be attracted. Here in Pakistan, unfortunately, local investment is not being made in Pakistan, and the investment is flying out of Pakistan. The contract enforcement, it has already been discussed that contract enforcement is important, and if there is a certainty in interpretation of contracts and in arbitration proceedings, if court understand that jurisdiction, before leaving judiciary, I have given a judgment in which I tried to explain that jurisdiction of a civil judge under section 9 is different from jurisdiction of same civil judge under the Arbitration Act. The scope there is very narrow, so the court cannot go into very details or overturn the decision of arbitrators. The court just has to look into the system and procedures to see that no irregularity touching the merits of the case has been committed. So thereafter is protection of property rights, and then is stable business environment. This all would come by the rule of law. And in summary, the rule of law provides the foundation of transparent governance, protection of rights, and a conducive business environment. By upholding these principles, countries can achieve economic stability and stable growth. Additionally, empirical studies have shown that positive relationship between rule of law and GDP per capita, emphasizing its importance in economic development. Now I hand over the mic to Mr. Justice Asim Hafiz, and the topic which has been given to Asim Hafiz Saab is investors' confidence and judicial decision, and exploring impact of judicial or foreign and domestic investor confidence. So I'll pose one question before he introduces his topic, so he may answer it thereafter or while replying to this question. Judge Sahab, my question is the role of judicial decision for investors' confidence. Is it not duty of the courts to settle the differences between the decision of judges of same strength. Like we in Lahore, I can give example that if a decision on a economic matter is given by one single bench, the other single bench, if has different opinion, would not refer the case to a larger bench. Instead, he'll give his own judgment, and then all these cases relating to economy shall be parked in intra-court jurisdictions and will not be decided for a longer period. So how would you highlight it, that how can it be addressed, or it can be thrown out of the High Court so that a final decision comes from Supreme Court? Thank you very much.
Thank you for having me here. But I think this is the nub of the problem, actually. The nub of the problem is that conventional wisdom requires that a case decided by one bench, an bench of equal strength, would actually have to honor that decision unless, and if there's a disagreement, the matter has to be referred to a larger bench. Because there we have a problem. We have a tax matter which is being decided repeatedly by 1, 2, 3, and 4 different benches unless the matter goes to the division bench and decides the matter. So what I think is that you are right that if a case has been decided and the law is laid down, then if there is any difference, the matter must go to a larger bench. Now coming to my topic, which is that how a judgment of a court would actually bring an economic development and prosperity. I mean, the question I'm asking myself is, provided a judgment of the court would bring an economic stability, prosperity, development, if it is implemented in letter and spirit, that's the problem actually. I'll come to that later on, but what is actually the economic growth is? Economic growth is actually a science of finances, which is being employed by economic institutions, and economic institutions are being set by the political institutions, the political power, which then give a legal framework for operation of those economic laws. Now, being a court, the foremost duty is to ensure that the legal framework within which the economic institutions operate is being implemented in letter and spirit. What it goes without saying that the judgment, how the judgments actually bring an economic development is, firstly, they, as my Lord has already pointed out, that they would actually bring a protection to the private rights of property. The protection to the private right of property is the most pivotal part, which actually encourages an investor to come forward and make an investment. When there is a capital investment that leads to a investment in a human capital, and that when a development or an economic growth is achieved. Secondly, how the judgment actually regulates the contractual obligation of the parties, which includes the contracts containing an arbitration clauses. Then what the judgment brings, the judgments actually provides for a clear and stable regulatory framework. What the judgment can bring is, judgment can check and control the bureaucratic, excessive, and arbitrary policies of the government. The judgment can actually bring more transparency in procurement issues. Judgments can curb corruption. So all these elements can actually lead to an economic development. So what I just conclude the matter is that it is actually the rule of law which translates, or which actually introduces an economic development or an economic growth. So that's it.
Thank you. My next question would be from Justice Mia Gul Aurangzeb Saab, before that he may answer the question after introduction of his topic, which also relate to the judiciary's role and economic growth. My question is that the ICA, because I just want that the identified issues may continue and be addressed in this interactive panel discussion. So my question is that in Islamabad High Court, there is intra-court appeal jurisdiction, and like in Sindh High Court and other, like I'm not sure about Peshawar High Court, the writ petition is heard by division bench. But in Islamabad and Lahore, it is being heard by the single bench, and very important commercial matters are parked in the uh, intra-court appeal jurisdiction. So my question is, why can't the High Court as an institution, which is being represented by you, this jurisdiction in commercial matters can be changed through rules, and why can't the matter relating to any commerce or economy, and maybe pecuniary jurisdiction or otherwise, it can go directly to division bench and from there to Supreme Court. Like for instance, may point out 7E's judgment uh, was given by me, which went in ICA and has been decided recently after many years. And whereas Sindh High Court's judgment has already reached Supreme Court, and almost all the process has been completed and it is about to be argued. But judgments of the Lahore High Court and probably of the Islamabad High Court has not yet reached there. And 7E is a very bigger issue, like it is pointed out, Justice Asim, that protection of property and taxation of property is the pivotal thing. Economy revolves around it, and but we are unable, as a judiciary, are unable to resolve 7E issue yet. Mia Sahab, please.
Thank Thank you, sir, for giving me this opportunity. In one line, the answer to that is fewer number of judges. But going into the background, the Islamabad High Court has adopted the Lahore High Court rules and orders. And in the Lahore High Court, initially, like the other high courts, the writ petitions used to be heard by division benches. And it was realized that too many judges are occupied deciding cases which can easily be dealt with by a single member bench. So therefore, a decision was taken for writ petitions to be heard by single benches, and for the provisions of the law reforms ordinance to be made applicable, and for there to be inter-court appeals. I do understand that it is time consuming, and there are two rungs of the ladder in the same high court that you have to climb before you go to the Supreme Court for a decision on a matter. But the Section 3 of the law reforms ordinance, after all, gives a very valuable right of appeal. It's a substantive right. There are also examples where judges sitting in the division bench set aside, and for good reason, the judgments passed by a single bench. This idea did cross our mind, and we sitting amongst peers sometimes have a degree of discomfort when we set aside the judgments of our brother judges. But this is something that we have to become immune to. This immunity is something that you have to acquire, and if you feel that the judgment merits setting aside, you should not hesitate in doing that, because after all, you have to uphold the principles of law. But the reason why we came to the conclusion that this should not happen in the Islamabad High Court is because of the sheer volume of cases. We are 8 judges and our backlog is 17,000. It is not humanly possible for us to adjudicate so many cases with such a small manpower. So therefore, there were certain cases which used to be heard by a division bench, like for example, the bails under the Control of Narcotic Substances Act. There, the administration committee took a decision for those cases to be now heard by a single bench. The entire rubric of this conference is alternative dispute resolution as a method of curtailing and reducing the burden of the courts. We in Islamabad Capital Territory have the Alternative Dispute Resolution Act of 2017. But the act was enacted, it did not precipitate amongst the litigants as well as the judges until a number of years. We were given a wake-up call by none other than the Legal Aid Society when they told us about this act and also wanted us to study the model in Turkey, where this law came in 2013 and had been a success story over there, in that more than 3 million cases had been decided through the process of mediation. In 2018, the mediation rules have been made in order to amplify this concept of dispute settlement. The foundational aspect of this concept in the ADR Act of Islamabad is the concept of consent. On the first date of hearing, the adjudicating officer, whether it's the High Court in original jurisdiction or the civil courts, have to give the option to the parties whether they want to resolve their disputes through consent. We, in order to make this process of mediation more robust in Islamabad, have issued practice directions to the judges. Initially, there was a degree of reluctance amongst the subordinate judiciary to go for this or to cause parties to agree to mediation. But we in the administration committee have now decided that the judges of the district judiciary, for a contested case, they get certain points. So if there is a successful referral to mediation and that results in a settlement, they will get the points of a contested case. This should be an impetus for them to refer matters to mediation. From the data that we have been given, Islamabad is divided into two districts. There is District East and West. In District East, the courts have referred 73 cases to mediation. Out of them, 29 have completed, 10 have been successful, and 19 have been unsuccessful. Now, this figure is not discouraging at all because it's the beginning. It's the beginning. And it is all very well for mediation not to be successful as long as the parties make an earnest effort to settle their dispute out of court instead of resorting to litigation.
Thank you very much, Mian Sahab. Sorry, I have to interrupt for the paucity of time. And inside next round, we have question relating to the figures which we are telling. And I'll hand over the mic to Justice Arshad Ali Sahab, I'm sorry, from Peshawar High Court. Yes. And after introduction of the topic, I'll ask you the question. So I'll not burden you with the question first. You may start with your introduction of your topic, please.
Bismillahirrahmanirrahim. Thank you very much for having us in this interactive session. And before coming to my topic, I would like to say that the opinion rendered by different persons, by different speakers in this interactive section were very enlightening for us. And I have observed in this session that a lot of work has been done on mediation and other things in this part of the country, that is Karachi, Lahore and Islamabad. But we represent a society which is indeed a war-torn society. And whatever has been done, it was not alone by the judiciary, but there are certain other institutions who are also working on these subjects. And I really appreciate the work of Naveen Merchant and Ms. Haya on this particular subject. And through this podium, I would also request them that they should also extend their expertise to the province of Khyber Pakhtunkhwa and the province of Balochistan. Now coming to the topic. The topic before me is the frivolous and vexatious litigation. Frivolous and vexation litigation is, I think, is known to all. The frivolous litigation is commonly understood in our society as a litigation which has been initiated without a probable cause or even without a sustainable cause. But it is very difficult to define this frivolous litigation. Whether the litigation from when inception was frivolous or after the conclusion of trial it became frivolous, or likewise whether it was the litigation which was launched by a person, it was a frivolous, or sometime we see that the defenses are also raised frivolously before the court. I was pondering that what were the main causes of initiation of these frivolous litigation. My conclusion are there are two main reasons. One is capacity, lack of capacity, and secondly is lack of legislation on the topics. So what is the lack of capacity? The capacity in this particular area, we have a trioca. The trioca of a lawyer, the judge, and the litigant. So we have first to educate these three stakeholders. How to educate a lawyer? Why the lawyer is bringing a frivolous litigation before the court? Either he does not know the law or he is intentionally doing it. The first thing which, when a case comes to a lawyer, he has to choose a forum. For example, in number of cases when contractual disputes are involved, there are arbitration clauses and they are filing a constitutional petition. The second responsibility is on the judge. When a particular list is brought before a judge, he has to evaluate the list. He has to see whether it was maintainable. But what we do normally is, for example, a senior lawyer is before the court. Normally we say, okay, notice to the other side. And after an year, it transpires before the court that the court had no jurisdiction. Now we do not have a mechanism to curb this kind of practices. And this requires, I think this requires legislation. In our country, I don't think that there is an effective legislation on this particular area, except in Islamabad there is an act, but it is not exhaustively dealing with the matter. The legislation, there should be, I think, my suggestion are there should be a legislation regarding curbing or at least reducing the frivolous litigation. For example, in some countries, we do have a legislation, more particularly relating to the vexatious litigation. There are certain jurisdictions where the the person who is litigating vexatiously, they are declared as vexatious litigator. And when they filing a suit, once they are declared as a vexatious litigator, then whenever they are going to bring a list before the court, first they will have to seek leave of the court. So we do not have any legislation on the particular subject. We need legislation on this.
May I put a question here? Because you have just pointed out that the filing of cases is the basic problem. So instead of waiting for a legislation to come,
Yes.
cannot courts administer or by amendment in rules, the court as an institution can bring some protocols which should be followed by a litigant, because it's very difficult. I am a lawyer now, so I can say it's very difficult to tell a lawyer that he should understand that he should not bring a frivolous case to the court. So when fee is coming and courts are entertaining all kind of litigation, so the lawyer will obviously go. The answer which is required is that can, through judgments or amendment in rules by a high court, some protocols are settled, like legal notice has become obsolete in this country.
Yes.
And it was a very important tool to bring forth or get registered the all important legal points, or which we now call legal objections, before the authority through a lawyer. And then thereafter, if there is no answer given after a reasonable time by that authority, 199 should be approached, and 199 itself says that alternate remedy should be availed first. But one
Yes.
way of controlling filing, and the other way, the Islamabad High Court in second round will learn from Justice Mia Gul that how they have introduced this cost system, and now they are getting form signed for the cost system. So please, thank you.
Yes, very true. I think there is inbuilt provision under the Code of Civil Procedure, and there are certain inherent powers of a particular court when entertaining a particular petition. For example, in CPC, there is provision Order 7, Rule 11 CPC. So, when a list is filed before the court has the ample power to evaluate whether the list is sustainable, whether it discloses at least a sustainable cause of action to proceed with the matter. And if the judge is of the opinion that it is not sustainable in the eye of law, then it can reject the plaint, can order for rejection of the plaint. And very true, yes, there should be certain protocols, and we have even the respective high court. I think in Peshawar High Court we have made certain amendment in laws. For example, the pre-trial proceedings, notices, case managements. We have also made efforts by amending the Code of Civil Procedure, and I think that yes, it is true that there could be SOPs, there could be a protocol for curbing that particular.
Thank you very much. I'm sorry, the mic is off. Our next participant, Mr. Justice Adnan Iqbal Chaudhary from Sindh High Court, and Sindh High Court is co-host of this program. So before handing over the mic, I congratulate also Adnan Iqbal Sahab, who is in the management I have just seen from since morning. So after introduction, Adnan Sahab, I'll just ask Judge Sahab you a question, or during your discussion I may ask.
Thank you, Shahid Sahab. Thank you everybody for being here. A special welcome to our guests from Azad Jammu Kashmir and from Gilgit Baltistan. Shahid Sahab, I'll jump straight to the topic. I believe you've been given a slip putting you on notice of the time. The topic is the...
You can give your point of view freely. I'll manage the late.
It's analyzing the role of the judiciary in dispute resolution and its implications for economic progress. Okay, the hypothesis that an independent judiciary significantly improves economic performance originated in the 16th century with the English philosopher Thomas Hobbes, who argued that without a judicial system, traders would be reluctant to enter into wealth-enhancing exchanges for fear that the bargain may not be honored. Therefore, the very concept of an independent judiciary had come about for the purposes of upholding or enforcing contractual rights. Now, as those rights evolved, as wealth expanded, it expanded into property, resulting in property disputes, and once again the judiciary was looked at as the institution for resolving those disputes. Fast forward, when countries started to make their constitutions, again the role of the institution that was given the job of enforcing that social contract between the state and its citizens came upon the judiciary. So in this way, the role of the judiciary has evolved over the years. So even today, when people go about in their businesses, make transactions on a daily basis, they do so with a sense of trust in the judicial system, that there is a judicial system that will come to our rescue or will uphold our constitutional rights, our property rights. It will come to our aid in the event of a state excess or state abuse. So that is how over the years, over the last few centuries, the role of the judiciary has evolved, it has increased uh, in the economics of the country. So for all businesses now, time is money. An investor will invest if he's assured that his contract will be enforced not only impartially, but also efficiently. Similarly, a lender will extend credit to businesses if he has confidence that the judicial system is there to recover the debt, that will get his money back. Uh, since the judiciary works on predefined or pre-existing legal commitments, be those commitments underlined in contracts or statutes or constitutions. So there is a sense of predictability, a sense of confidence that the judiciary would decide in A way or a B way. And this is how the judicial system has come about, and this is how it has over the centuries contributed to investment, trade, and economic progress. Now, having said that, a number of studies have shown that money spent on the judicial systems in the form of law reforms or judicial reforms, be those in the strengthening of the number of judges, the training of judges, the upbuilding or modernizing the infrastructure of the courts, that has all eventually returned in a higher GDP, and which eventually develops the market economy. So, and that is why global lenders, such as the World Bank, the Asian Development Bank, the USAID, have been funding judicial reforms, judicial reform projects ever since the early 1990s, because it is documented. The figures show that eventually these reforms come back and assist economic progress of that country. So the converse is equally convincing. If you don't invest in judicial reforms, that will eventually lead to corruption, to lawlessness. It then pushes people to seek redressal by way of informal or illegal means. And so therefore, the investing in the judicial system should be a no-brainer for any government. But sadly, that has not happened. The last time the strength of judges was increased was maybe 20 years ago. The population has since exploded. Crimes and disputes have multiplied dozens of times. The number of judges remains the same. So here we are performing to the best of our abilities at full capacity, but the performance of the judges seems to be eclipsed
Yes,
by...
sorry for interruption here. One question in continuity of things what you're saying is that we are here, in fact, what we are discussing is that in available resources and within the available laws, what judges can do and change through their decisions, and the high courts as an institution bring some amendments in law and procedure, or whether should there be a judicial policy of an institution of an high court, like
Ji.
full court meeting you
Bachar
see
sir, ji, I get
is
you.
a tool where you can sit, and I think you should discuss there that how cases should be. And the question in this backdrop is whether there should be specialized benches in the available strength of judges, so that a person who starts his day with as a judge, he has to deal with one kind of cases. For example, if it is family, or like, for instance, once I started hearing cases on specific relief act, the suit for specific performance. So after some time, there were few judgments which were being relied upon, and there was few set of facts common to all the cases, and a one day's hearing, other day everything was on my tips, and straight away after 2 3 questions, whether this thing is done, Supreme Court has decided it, and it will just pass on. You can get rid of backlog by giving one kind of work to one judge. This is not the speciality of the judge, which is one thing that which you can create for a judge, and for 1 month or 2 months thereafter he can be shifted, because there is an argument in High Court I've also been facing. I was tagged as a tax judge. Despite doing many other work, still people call me a tax judge. So a judge's specialty is one thing, and you give a certain kind of work to a judge so that his specialty is created and then he can be moved somewhere else. So my question is whether judicial policy in the full court by the judges themselves, by discussing. Normally what happens is that they tell that this much was filing and this much we have decided and this much is done away with, and sometimes we change the jurisdiction and refer all the cases back to the civil courts. So this precisely is the issue. As an institution, how would you respond to it?
But Shah Sahib, that's what I was really about to drive at, was that the entire focus or the entire spotlight is on the judiciary. I'd like to throw some of that back to the government. So that's what I was trying to emphasize, that alone the judiciary can't really address everything. So there has to be support from the executive, from the legislature, and of course from the bar. So I was just trying to share the spotlight, to spread the spotlight all over. The judges are performing to for full capacity, but the point was that it's not the performance is being eclipsed by complaints of delay and time consumption. So there's a reason for that. It is that law reforms or investment in the judicial system hasn't really happened over the year. Now coming to your question, what can the judiciary itself do about it? Yes, given the resources that we have, if left to our own devices, we can make rules. The civil procedure empowers the high courts to make rules. Yes, we can on our own take certain reforms within the given legal framework. But Shah Sahib, what has happened is that given the huge backlog and the huge amount of work involved, there is the entire day of the judge really consumed by firefighting. So he's firefighting all day.
You're true.
If you want him to actually apply his mind, you need to give him some time to read up on things, to think about things, but that's not happening. So there is no time left for a judge to...
So thank you very much. We will move forward and we'll come back on these all questions. In second round, you can answer or you can point out anything which we have already discussed. Now coming to Chief Justice Saab of Gilgit-Baltistan, Justice Ali Beg Saab. I personally confess that I do not know much about Gilgit-Baltistan, so we need an introduction of Gilgit-Baltistan courts and system there. And I have heard that a law has been passed on mediation recently in Gilgit-Baltistan. Thank you very much.
Bismillahir Rahmanir Rahim. Honorable serving and retired judges of superior courts, lawyers, distinguished participant and organizer of this event, Assalamu alaikum. It is great pleasure and honor that I stand before you today at Pakistan International Dispute Beacon and to discuss crucial aspect of our nation, growth, prosperity, and my topic is recommendation for Pakistan to enhance economic development from judicial perspective. As we are gathered here to deliberate on the matters of dispute resolution and the legal framework, it is imperative that we recognize the pivotal role that judiciary plays in fostering economic growth and stability in our beloved country. Pakistan, like many other countries, faces many challenges in respect of economic prosperity. While, although we have made significant strides in various sectors, there is still much work to be done to ensure sustainable development and inclusive growth for all our citizens. One of the key pillars of a thriving economy is robust and efficient judicial system that upholds the rule of law, safeguards prosperity, and ensure fair and transparent dispute resolution mechanism. In order to enhance economic development from judicial perspective, I would like to propose a few recommendations that I believe can pave the way for brighter future for Pakistan. Number one, strengthening the rule of law. The foundation of a prosperous economic law is in strong and independent judiciary that upholds the rule of law without any bias and favoritism. It is imperative that we work towards enhancing the capacity and the effectiveness of our judicial system to ensure timely and fair resolutions of dispute. Number two, promoting investor confidence. Investors are more likely to invest in a country where they have confidence in legal system. By ensuring a predictable and transparent legal framework, we can attract more foreign direct investment and stimulate economic growth. Number three, improving contract enforcement. Efficient contract enforcement mechanisms are essential for business to operate smoothly and for economic transactions to take place seamlessly. We must focus on streamlining contract enforcement procedure and reducing the backlog of cases in our court. Number four, embracing alternative dispute resolution ADR mechanism. ADR mechanisms such as arbitration, mediation can provide faster and cost-effective resolution to dispute, thereby reducing the burden on our judicial system and promoting a business-friendly environment. Five, investment in judicial infrastructure. Adequate investment in judicial infrastructure, technology, and human resources is essential to ensure the efficient functioning of our court and to expedite the resolution of cases. As said by our panelists, Gilgit-Baltistan is a region in northern part known for its stunning landscapes, rich culture, heritage, and strategic importance. It is a home of diverse population comprising various ethnicities, languages, making it a melting pot of culture and tradition. The region is blessed with natural beauty, including majestic mountains, serene lakes, and lush valleys, attracting tourists and adventurers from around the world. In terms of judicial system, Gilgit-Baltistan has its own judiciary with Gilgit-Baltistan Chief Court serving as a high court in the region. We have also a Supreme Appellate Court whose Honorable Chief Justice is sitting here. He has also participated in this event. The judicial system in GB plays a crucial role in upholding the rule of law, protecting the rights of the citizen, and ensure access to justice for all. The judges and the legal professionals in Pakistan work tirelessly to dispense justice fair and impartially and contributing to our all development and stability of the region. Despite challenges and constraints, the judicial system in Gilgit-Baltistan continue to strive for excellence and efficiency in the administration of justice. The judiciary Gilgit-Baltistan is committed to upholding the principle of justice, fairness, and equity before the law, thus playing a vital role in maintaining the social fabric and fostering trust in the legal system. We have also we have 10 district and 10 district and session judges and about 24 civil judges working as judicial officer in various districts. These are our setup. Thank you very much.
Thank you very much, Ji. Thank you very much. Before starting the second round with the questions to the panelists, I would request the organizers to arrange a mic that anyone who want to ask any question to any of the judge during his reply, or he may raise hand so that we can make it more interactive. So my question, anybody from the audience if want to, they can just raise hand. We can attend the question during our discussion. Asim Saab, first of all, the question have already been asked. I do have few more questions in mind, but on the questions and discussion already made, if you want to add to anything like changes in rules and administration and control by the decision, if you want to add anything.
After all this discussion, there is one thing which I think I should express my opinion, and this is my own personal opinion. My High Court has nothing to do with that opinion. I mean, lot has been discussed about the courts. Lawyers were put in the docket, judges were put in the docket. The only issue is why, despite all our efforts, we have laws, we have judges working from day to night, 24/7, why the foreign investment is not coming. What is the only difference, perhaps, is that we are not accounting for the difference between a de facto and a de jure political power. Unless we have a political stability, I don't think so. What to talk of a foreign investor, no local investor would actually invest. So that's actually the problem, I think. We are delivering judgment, administration of justice is there, everything is there, but the problem is that unless the legal and the political framework is so stable and is so secure that a gentleman walking in the street will trust it, I don't think so that a foreign investment or local investment will come. And all these grand declarations about media and all these grand declarations about mediation, administration of justice, courts, I think it can be a topic of discussion, but nothing would come out of it. Thank you.
This discussion, the topic has been started by Justice Asim, can go miles away because the only focus at the time is what our topic is, and this is because of the misconception I have already told, that it is misunderstood by everyone that administration of rule of law is only by the judiciary. So certainty has to be brought.
The regime that Pakistan has for the enforcement of foreign arbitral awards, the answer to that is yes. We have it in the form of the Recognition and Enforcement of Foreign Arbitral Awards Act of 2011. It was preceded by as many as, I believe, 8 ordinances commencing from the year 2005. And it is in recognition of Pakistan's obligations under the New York Convention of 1958, to which Pakistan became a signatory in 1958. But it took several years for the process of domesticization to take place, because the mere fact that Pakistan has become a signatory to a treaty does not make it a part of the laws of Pakistan unless legislation on the basis of that treaty is made, incorporating it into the law of Pakistan. The schedule to the 2011 Act is the New York Convention, and there's a provision in the Act giving it primacy over the provisions of the 2011 Act. When there is a foreign arbitral award as defined in the 2011 Act, the High Court has the exclusive jurisdiction where an application can be filed for its enforcement. The party against whom the enforcement is to take place has been given the option to resist its enforcement by filing objections. Those objections have to be restricted to the objections which are enumerated in Article 5 of the New York Convention. The objections, as we commonly know, under Section 30 of the Arbitration Act 1940 do not apply here. You have to look at the case with an extremely narrow spectrum. Whether an award can be challenged by courts in Pakistan is also to be determined in accordance with the law that governs not the substantive rights of the parties to the underlying contract, not the governing law of the agreement to arbitrate, but the governing law of the procedure for arbitration. So if the governing law of procedure for arbitration is specified in the arbitration clause, then it is in the courts of that country which governs the procedure for arbitration. Otherwise, it is the seat of arbitration, the courts of the seat of arbitration to which the challenge will lie. Courts in Pakistan, the Sindh High Court, Lahore High Court, the Islamabad High Court, there are now umpteen judgments where arbitration awards have been enforced. There are two judgments of the Honorable Supreme Court of Pakistan, where one of them upholding a decision to enforce a foreign arbitral award, another setting aside a decision of the Lahore High Court where intervention was made in a foreign arbitral award. So that is a welcome change and a breath of fresh air for economic stability in the country.
Gulsab, there's another question. Having said that it's not the only duty of, not only duty of the courts, judiciary to enforce the rule of law. Becoming devil's advocate, if I ask, this question must be in the mind of many people, that High Court having jurisdiction under Article 199 and Supreme Court having jurisdiction under Article 184(3), and Supreme Court can take suo motu notice as well. When the fundamental rights are not being performed and the institutions are not functioning, protecting people's right, which has to lead to the certainty in the system, do you think that this continuing mandamus, a concept which was introduced in recent past, is a solution for taking over by the judiciary for rule of law and making an environment conducive for economic growth? Thank you.
The power under Article 199 of the Constitution is not a very wide power. It is circumscribed. And that parameter for the exercise of that jurisdiction has been laid in judicial precedents from the High Courts as well as the Supreme Courts. As far as the parameters of mandamus are concerned, that are very well enunciated in Article 199. You will issue a command to the government to do what it is supposed to do under the law, prohibit it from what it is not supposed to do under the law. But now that we have the judgment of Sophia Wakar, it has taken away the jurisdiction of the high courts to exercise suo motu jurisdiction. Why I say taken away is because earlier there were cases where the high courts did exercise this suo motu jurisdiction, and the exercise of that jurisdiction was most conducive to the rule of law and for the system of governance. I recall in 1999, the Honorable Mr. Justice Ajmal Mia writing in a judgment saying that whether Article 199 gives the High Courts the power to suo motu exercise jurisdiction is a very debatable point, and we need to delve into it very deeply. You would, if going through the Sophia Wakar case, you will see that it deals with the matter extremely in a cursory manner. There is no in-depth analysis of this jurisdiction. So I would urge the Honorable Supreme Court at an opportune juncture to readdress this issue by not bearing in mind that some of us are trigger happy and would venture into jurisdictions where we are not supposed to. Give us the benefit of the doubt. And in India as well as Pakistan, the exercise of this jurisdiction has been extremely conducive. Don't just leave it to the Supreme Court, share that jurisdiction with us.
Thank you. I think it has already been said by Justice Asim very boldly that fault lies primarily with the political system, and there's no consistency in the policy. And one thing I want to make clear is that lack of trust in our system by foreign investor is not only because of political instability, but inconsistency of policies. Policy making is not the job of judiciary. Please understand this, the policies, the power policy, and some of friends sitting here, I was very prejudiced about the IPP contracts, and he, after discussing with him, the idea originally I was told was very viable, and it was same idea was taken up by the Turkey, and the model is successfully being done there. And now the energy companies are selling energy privately like mobile phones, but unfortunately the person who succeeds or the party who succeeds the previous government, they just put on a tag of corruption on the policy, and the policy is thrown in dustbin. This is the basic reason of foreign investors not to come here. So far, interpretation and implementation of the contracts and their implementation is concerned, yes, this is the area which we are discussing here, that our system in lower courts and in the high courts is not providing expeditious justice, and that's why one of the tools which has been introduced worldwide and being encouraged worldwide, the courts under their supervision have started referring the matter to mediations under their supervision, and this is one of the way of getting the dispute resolved, in particular relating to an economic matter. Any other participant, if you want to add to this question, answer this question? Yep.
I think I agree with you. The problem is with the courts. But what we need to do is actually, we need to legislate on putting a heavy cost. If I share my experience with you, every day we have to deal with 20 to 25 urgent cases relating to family matters. When the law only provides that only one appeal is available, why the matter ends up in the High Court? Why every day we are coming across a judgment by the Supreme Court on family matter? Why? Because the courts are actually encouraging the issue. So that's the problem actually. When you decide 25 family matters in a day, you don't find a time to decide main important cases. That's the problem. We need to actually put heavy costing on that to stop frivolous litigation. Thank you.
Cost pe aapne, sir, you had asked about cost. In Islamabad, unlike the other provinces, we have the Cost of Litigation Act 2017. That act has brought about an amendment in section 35 of the Code of Civil Procedure, giving the High Court the power to impose costs, not in the sense as to the costs following the event, the actual costs that the winner has, the loser has to pay to the winner, but other than that, there are punitive costs that are to be imposed, and it is permitted as far as this act is concerned. In order to make that into a robust exercise, what the Islamabad High Court has done is that in exercise of its constitutional power under Article 202 of the Constitution, it has made rules as to how the cost regime is to be implemented. whenever a civil litigation is instituted, there are a number of mandatory forms that you have to file. Costs form has now been made mandatory. So a suit is not going to be numbered unless it is accompanied by a costs form. In the High Court, a writ will not be entertained if it is not accompanied by a cost form. And so is the obligation as regards the written comments and the written statement is to be filed. The defendants have to, under an obligation imposed by law, impose a cost form. Now, there has to be a change in the hearts and minds of the judges. These laws by itself will not work. There can't be a good judge and a bad judge. There cannot be Justice Asim Hafiz who imposes cost and me being a good judge saying that no, I'm just going to dismiss cases. That will be an impetus to frivolous litigation. So there has to be a concerted joint effort made by the members of the judiciary, whether the district judiciary or the higher judiciary, to make this concept in tandem and in link with other developed countries of the world.
For the discussion we had, I think the time is over. The last 10 minutes are not pointed out to me, so I believe that time is over. Shiraz Sahab is giving smile, and thank you very much for all the panelists.